Maneva na sema PENDREAM TV. PENDREAM TV de osia dem yopo.
Right, Sever Tem. We're going to go onto the phone as well and speak to the Director of Legal Affairs for the NDC, Godwin Edudzi Tamakloe, on this. But let me just complete the walking through the timeline, and then we'll go to Edudzi Tamakloe. Then we'll return to the basis for her appeal before the courts today, upon which her acquittal and discharge has come forth from the Court of Appeal. Now, in December of last year, a U.S. arrest warrant was issued. And subsequently, we know she was arrested in January of this year in Nevada and was brought into the jurisdiction. And there were lots of questions as to her whereabouts, amongst many other things. But let's go onto the phone lines right now and speak to Godwin Edudzi Tamakloe, who is the Director of Legal for the NDC, and quite interestingly, at one point in time, stood as counsel for her as well. Counsel, appreciate you. You're quite familiar with this case because you once served, like I was mentioning, as counsel for the now freed Sedina Tamakloe. Yes, Mr. Tamakloe, why are you saying something?
Can you hear me?
Yes, I can hear you.
Yes, I'm saying that good afternoon to your viewers. First of all, I've never represented her. I've never been loyal for her as far as a case was concerned.
Absolutely.
I'm just speaking as a private legal practitioner, seized with some of the surrounding circumstances. Beyond that, I didn't have the personal conduct of the case.
Right. So let's zoom straight into it as well, because the suggestion is that it's been all very convenient, the manner in which things have played up until this point, this acquittal and discharge.
Once appealed is reviewable by a panel of 3. That panel of 3 have every right to come to a conclusion different. And if you look at our jurisprudence, it is replaced. In fact, just a month ago, the Court of Appeal reversed a judgment on the narcotics case unanimously. And so this is nothing strange. The only challenge we have in this country is that usually when you are prosecuted, people do not want to see that your prosecution is based on what the individual is alleged to have been done. That in terms of group tax and what have you. But beyond that, I don't see anything so strange about the Court of Appeal reversing a judgment made by a trial judge at all.
Right. The argument is that this is convenient, particularly for her, and a bit too fortuitous, considering that she was returned to the jurisdiction. In fact, there were arguments as to whether or not she had been sent to prison to start off with, which drew statements from the Interior Minister, amongst other things, suggesting same had been done. And now she files an appeal on the 12th of this month, and the court sits, hears the appeal, and she's acquitted and discharged, when other cases, for instance, have been before that same Court of Appeal and yet to be heard.
Who am I speaking?
Mawina here, Counsel.
Egbeto.
Yes, Egbeto.
Sorry. Oh, Mawina. Sedi has been in this country for some months now. You're a senior journalist. Did you get the benefit of verifying that she was not in Nsawam? At least, let's take me out of it, so that at least at the barest minimum, you will not be repeating such unfounded claims on TV. There's record, which record is easily ascertainable, that she had been in Nsawam prison. Is that a convenient proposition to make? With respect, if you have a situation where an appeal was mounted many times ago, many years ago, and submissions were filed many months ago, I don't know what you want done. Are you saying that you disagree with the judgment, a judgment that you and I are yet to read?
No.
What would be the basis?
Right.
And when the suggestion is made that it is convenient, what would be the basis of that claim of convenience?
Granted, and the point I make was in relation to the conversation surrounding before we got to know as well that she had been taken into prison custody. There was the conversation and questions being asked, but that's beside the point. The argument which has also been put forth by the minority, which is a criticism, is that with regards to the optics, it doesn't look quite good for the NDC who say they are engaged in oral, amongst many other things, for someone who's been convicted. Suddenly, the person has been acquitted as well. That's one of the many criticisms which is coming forth from your opponents.
The reasoning I get from your questioning is that it doesn't matter whether there was evidence to support the conviction. Once it meets a certain optical thing, it's enough to put the person in prison. Have you been in prison before? Have you spent a day in custody before?
Absolutely not, Counsel.
So you can have that convenient conversation. You can have that. You can play balls with the liberty of an individual to satisfy a mob. I mean, that's your cup of tea.
Right.
It's stressful. If you have been in custody for even a day and you strongly believe that there's no basis for your conviction, even a day in prison will be the most horrible thing to happen to you. And let me say, have you even looked at the record of proceedings? Look, Sticker. You know Sticker?
Yes.
Sticker was a prosecution witness in this case. Under cross-examination, he was specifically asked, was one cedi paid by Sedina for those buses? His answer was no. And that he, as Sticker, was the one who came and renegotiated the contract. And this person is supposed to be in prison for that. Get the opportunity to read the entire record and see if those doubts in the prosecution's case ought not to be resolved in favor of the accused person.
Counsel, perhaps the final question I'll ask is in relation to the judgment, right, of Ifiasa Rebotwe on one of the count of stealing, where the argument was made in the reasoning of the learned judge that in one of the instances where there was a claim of monies for sensitization and a specific workshop, some 1.7 million cedis, there was no evidence as to the workshop being done. Prosecution argued that even the regional officials and all of that could not verify if the workshop or the sensitization exercise had been carried out. And her absence to have been in court to prove that indeed it happened, because the burden had shifted from the prosecution to her absence constituted a part of the reason why she couldn't disprove that prima facie evidence which had been placed on her. That argument has been made that her absence as well could have gone against her in that trial.
Look, the burden is still on the prosecution to prove her guilt beyond reasonable doubt. They failed to do that. Let me go back to the records. And because you raised the issue of records, if you look at volume 5, page 64 of the records, this is the exchange that happened between the prosecution witness and counsel for her. Question. The officers who wrote statements indicating that they were sent to cash checks and handed over the monies to A1 did not indicate that there was no sensitization. Is that correct? Answer. That is correct, my lady. Do you still stand by your claim?
Well,
do you still stand, from what I just read and across, do you still stand by your claim?
Then that will prove, amongst many other things, perhaps the basis upon which the Court of Appeal has arrived at that decision.
What are you talking about? You have not even addressed your mind to the record.
No, I have read the judgment.
I mean, it's like a bull in a china shop. Go back to the records. The prosecution witness were specifically asked that none of the officers indicated that there was no sensitization. And the answer by the prosecution witness was, yes, my lady.
For you, that disproves their case completely.
Based on your claim, does it not controvert your assertion?
Well, it will suggest same, will it not?
So if there is a doubt from your learning, when should the doubt be resolved in favor?
Well, Counsel, appreciate their insights and the details, and we'll look forward to.
Please, you say we should go back to the records.
Right. Certainly. Appreciate you speaking to us. That's Edudzi Tamakloe. He is Director of Legal of the NDC, speaking to us this afternoon in relation to the acquittal, right, and discharge of Sedina Tamakloe in relation to that case brought against her, convicted, sentenced to 10 years. The Court of Appeal acquitted and discharged her. Looking forward to the full reason. We understand is a 94-page reasoning of the Court of Appeal, which says that the prosecution did not discharge the burden of proof in relation to the charges brought against her, resulting in an overturning of the ruling. But we understand the news just coming in is that the AG is set to appeal this particular acquittal and discharge of Madam Sedina Tamakloe at the Supreme Court. I'm sure there will be a bit more in terms of details from that, because we're expecting the Attorney General as well to be addressing the country a lot later this afternoon at 1 p.m. as well. And so there will be a lot more, and certainly not the last we're hearing of this particular subject matter, Kemini.
And when the Court of Appeal talks about prosecution did not have enough evidence, that prosecution was led by Godfred Dame, the former Attorney General. We've also been hearing from Dame's deputy at the time he was in office, Alfred Chiayeboa, who's also expressed shock at the ruling. He insists that Sedina has been left off the hook. Take a listen.
Here's the case that in the trial, the CEO, Madam Sedina, advanced a loan facility to a microfinance company in Ashanti region, the sum of 500,000 Ghana cedis by way of checks. The company said they were not interested in the amount again because of the interest element. So they decided to return the check to Madam Sedina Tamakloe. She requested that, no, cash the money for me. They cashed the money, came to Accra at a filling station, gave her the 500,000 Ghana cedis in Ghana must go back. She took the money and issued a receipt on her own. But that money never went into the books of Masloc. All these things were made available to the court. And if the Court of Appeal can say that with this strong and very potent evidence, the state could not prove any of the charges, that's what I'm saying. I'm very much sad.
Let's tell you a bit more about this developing story now. Mawena Egbeta is at the dashboard with all the details that you need to know. And Mawena, we're talking timeline of the event. We're talking the judgment from the original conviction, back then, 3 years ago. We're also talking about what we know so far about today's decision by the Court of Appeal. What are you learning?
Well, let's start off first from the timelines, right, as to when all of this began and where we've moved from up until now. And power changed hands by December 7, 2016. There was that elections which was held immediately. There was an Iyoko investigation which began in 2017. Now, after that, a forensic audit as well was commissioned into the operations of the Microfinance and Small Loan Center, Masloc. From there, the Iyoko took hold of the forensic audit report and covered alleged financial irregularities during her term at Sedina as chief executive between 2013 and 2017. And so investigations took some time. By January of 2019, she was put before court, and then the trial did begin. So 78 counts, including conspiracy to steal, stealing, willfully causing financial loss to the state, conspiracy to cause financial loss to the state, causing loss to public property, improper payment of public funds, right? It's very important to keep in mind what these counts or charges are, because if you read the judgments of the learned judge, right, and they establish a number of things, that there was a misappropriation to a certain extent, and then once that was established, it fell in line with all of these, some of these counts, making it very simple to then proceed forward and then mention on counts so and so and so. We find A1, the first accused, Sedina Tamakloe, convicted of the offense amongst other things. So very important, because you see causing loss to public property amongst other things, and you're wondering exactly what that means. We'll seek to provide a bit more in terms of details. Also, unauthorized commitment resulting in financial obligations to government, allegations of money laundering, breaches of the Public Procurement Act, because in some of the purchases, right? For instance, for the 100-seater buses, amongst other things, which constituted some of the gravamen of offenses which went to the court, the evidence which had been put before the court by the prosecution suggested that, look, contracts were signed or payments were advanced to a certain extent before contracts were signed, which will bring into question breaches of Public Procurement Act, amongst other things, in relation to the matter. So, the trial then began in January of 2020, right? 2019, I beg your pardon. By February 2021, she put in a request, an application to travel. The High Court granted that permission to the United States for medical treatment. It's an important part of this particular trajectory which we're on, right? Because her decision to seek medical treatment outside of the jurisdiction will prove, or did prove, fundamental in the decision which was arrived at by the court, where certain arguments were advanced by prosecution which required responses, because the court believed that a prima facie case had been established and there was the requirement for her to punch holes. Her absence, amongst other things, per the court's ruling, proved as basis for her conviction in some of the instances. She failed to return to the jurisdiction after the court approved that travel, and subsequently a warrant was issued for her arrest, and the trial continued in absentia. In fact, in all of the talk about Ken Oforiatta and the many things, this has been cited as an example that the trial proceeded in her absence, and so same can be done for other persons in the jurisdiction, amongst other things. By April 16, 2024, a conviction and a sentencing was made known to the entire public. Justice Efia Sewa Asareboche convicted her in absentia. She was sentenced to 10 years in prison, and her co-accused, Daniel Axim, was the second accused in the matter, was also convicted, was sentenced to 5 years in prison. Daniel Axim began serving his term, but subsequently has proceeded to the courts appealing this decision and has been granted bail pending appeal. Questions which are being asked as to what happens to him if Madame Sedina has been acquitted and discharged by the courts now. It presupposes the remnant will affect him as well. But we'll get into those conversations as well for you subsequently. So the court found her guilty on numerous counts, including stealing, conspiracy to steal, willfully causing financial loss to the state, causing loss to public property, money laundering, and procurement-related offenses, right? Procurement-related offenses. Then the trial court also directed the prosecution to commence forfeiture proceedings against her. Then power changed hands, before power changed hands, right? Extradition efforts began by July of 2024. Let's go back to when the conviction came. April, July. extradition proceedings then began in seeking to, amongst many other things, have a return to the jurisdiction and answer or serve a term.
Let's take a listen to the lawyer for the former Masloc CEO speak to our court reporter after the ruling.
Firstly, let me seize the opportunity to thank my lords for, in fact, for agreeing with us that in fact, for agreeing with our submissions. So we thank my lords for their erudite reasoning. However, we would just wait for the entire judgment. My lords have said that the judgment will be ready by close of today. So we'll take get copies of the judgment, and then we can peruse it, and then we can make comments subsequently. But I am a happy person, and I believe my client is also will also be happy.
Essentially, what was the gravity or gravamen of your appeal before the Court of Appeal? What were the grounds that you were seeking from the Court of Appeal?
Oh, in fact, I would say in terms of strategy, okay, we had come essentially on 3 main grounds. On the fact that the charge sheet itself was defective, and then secondly that in fact there was no prima facie proper prima facie determination against our client, and then of course we also attacked the judgment itself. So these were the grounds, but as you may have already heard, in fact the court only read their conclusion, and then they only dwelt on the first leg of our submission, which was the defective charge sheet.
As we speak, what's the state of your clients? How is she doing now?
Well, I'm here to speak to her, but I mean, as we all know, she's in Sawom, and I'm sure she may have already heard the news, so I'm sure she'll be happy. Yeah.
All right. Thank you.
Are there any other options that you seek to take? Perhaps some civil action against the state?
Well, I don't have such instructions now, but I'm going to sit with my client, and then on the basis of the judgment, we'll see what steps we can take.
Enoch Degbe is counsel for the former Masloc CEO, Sedina Tamakloe. We'll stay on the story because this mind-splitting decision by the Court of Appeal has a bit more to it than we have already told you. We'll connect now with our court correspondent who's been observing the situation since the decision was made earlier today. Lord, what else can you tell us about this ruling?
Sedina's case. Yeah. Well, have you sought a comment from the Attorney General? Seek a comment from the Attorney General, because Sedina was convicted on very credible evidence and all, and he conducted the appeal. So find out from the current Attorney General what he feels about the acquittal of Sedina and why Sedina was acquitted. I don't know why she was acquitted. So find out from the current Attorney General why that happened.
But
and what he feels.
You didn't prove your case beyond
it cannot be the case at all. You see in the judgment of the High Court, yes, Sedina actually absconded after she had actually been confronted with the evidence led by the prosecution. It was not for nothing. So I'm saying, find out from the current Attorney General, do you know the kind of opposition that he mounted to the appeal? Or was there any opposition at all? I don't know. That's it.
Is all going well with Hanan's case?
As far as we know, yes. Apart from
you had your
halt proceedings and to go to the Court of Appeal.
That was dismissed.
Yes, and unjustifiably, as far as I'm concerned, because the matters that we raise are very fundamental. The charge sheet is very defective, or defective not only because of 2 counts that the judge struck out the last time, is the whole of the charge sheet is defective. And I think it's important that the Court of Appeal determines it, and we have filed an appeal and repeat the sort of proceedings. It's important that we know that when the state proceedings is refused at the High Court, we can repeat it at the Court of Appeal. So we indeed repeat the stay at the Court of Appeal.
You didn't seem pleased when the charge had indicated that he'd be sitting throughout the legal vacation, especially after getting a circular from the Judicial Secretary.
Yes, because that's unjustified haste, and that is unprecedented. It has never happened at all. I do not understand why they are in such ambulance haste. I mean, in the days of the NPP and all these trials were going on, did you see any of them being conducted in the vacation? Never at all. Never at all was any person tried in the vacation. Has never happened since 1982, and I do not think it should happen. And indeed, we protest the directive given by the Chief Justice for it to happen now. Why? What's the exceptional circumstance here? Why so much urgent need to have accused persons tried in the vacation? If we've not been able to try all along, it's not my fault. It is their own doing that they discontinue the prosecution and all that. If all the charges have been defective and they decide to withdraw at one point and come back and they have been ordered to amend and all that, it's their own doing. It cannot be as a result of my default. And so there's no justification for the order for the accused persons to be tried in the vacation. We are going to protest the directive and we'll do so accordingly.
I mean, back to the Sedina, will you advise the Attorney General to appeal the decision of the Court of Appeal?
Oh, definitely. I mean, when I was in office and there was acquittal by the Court of Appeal, certain accused persons, I appealed to the Supreme Court. But the same Attorney General came and discontinued the appeal. So I would therefore not be surprised that it does not even file any appeal at all in this matter. We saw it in Woyome. In Woyome, when they purported to put Woyome on trial on some defective charges and the court acquitted. They appealed to the Court of Appeal affirmed. They never appealed to the Supreme Court. They never even put the right persons on trial in Woyome. And to date, we know what has happened.
Thank you. All right, Kemini, and so you heard the former Attorney General, Godfrey Ebadame. He was the Attorney General during the prosecution and eventual conviction of the former Masloc CEO, Sedina Tamakloe Ationu. Heard his comments over there about questioning the reason for which the Court of Appeal discharged and essentially acquitted the former Masloc CEO. Now, just to run you through a few reasonings that the Court of Appeal indicated. Now, one of them that they stated was that the trial judge in the matter assumed guilt of the accused person before the case was done. Also indicated that the prosecution transferred the onus or the proof to the accused person. And then finally added that the prosecution failed to prove beyond reasonable doubt the ingredients regarding the charges which were preferred against Sedina Tamakloe Ationu. Kemini.
I see. Lord, we'll leave it here. Thank you so much for the report. And Lord Edudzi is just engaged with the former Attorney General on the steps of the law courts here in Accra. He's responded to the opinion splitting decision taken by the Court of Appeal to discharge and acquit Sedina Tamakloe, the former Masloc CEO.
Whenever I say PENDREAM TV, PENDREAM TV, dear, I see them, yopo.